Hi, I'm Emily, and I am here with Maya Murphy's attorney, Eva Marie Franco Fox. Attorney Fox practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fox is, my partner and I are negotiating a prenuptial agreement. Are there any issues that cannot be included in this agreement under Connecticut law?
Thank you for your question, Emily. This is a really important question for people to know and understand when contemplating whether or not they're going to enter into either a prenuptial or postnuptial agreement. Generally, in Connecticut, the parties are free to contract around their financial and their property rights when entering into either a prenup or a postnup. They can customize the agreement so that they can address things like how to treat their income, their assets, their expenses, their liabilities, and other rights in a way that would deviate from what Connecticut law would generally dictate in the event of a dissolution or a death of one of the parties. However, the court certainly, or the laws in Connecticut certainly prohibit the parties from entering into certain or including certain provisions in their agreement that otherwise the parties would want to contract around. So, for example, child support. In Connecticut, we have laws that govern child support, how it's calculated, what factors are considered, and so the courts don't allow the parties to preemptively contract around child support. The courts are governed by this best interest of the child standard, and the courts need to know that at the time of enforcement, the best interest of the child is actually being considered. And so the courts don't allow parties to proactively contract for child support because they may not be aware of how their circumstances are going to change over time, and so they therefore can't fully address what the best interests of the child may be at the time of dissolution or at the time the enforcement of the agreement is sought, because their circumstances are very likely to change from when they entered into the contract and when they're seeking enforcement of the contract. Also, child support is thought to be the right of the child, not necessarily the right of the parent. And so the court, again, would need to assess what's the child's rights and what is in the child's best interest at the time enforcement is sought, as opposed to potentially years earlier when the agreement was being negotiated and contracted for. Another provision that generally the courts would prohibit from being included in the agreement is a waiver of spousal support or alimony if that waiver would render the party reliant on public assistance. So generally in Connecticut, yes, the parties have the right to waive alimony or spousal support, but if that waiver would render one party destitute or reliant on public assistance, the court has the authority to determine that that provision is unenforceable. The state has an interest in ensuring that the spouses are going to be taken care of and the spouses aren't going to be reliant on any kind of government aid, and therefore it would generally be considered against public policy to include a waiver that would render one of the parties incapable of supporting themselves. Now, this is true even if the waiver would have been enforceable at the time the parties entered into the contract. So, for example, the waiver wouldn't have rendered a party reliant on public assistance at the time that they entered into it, but really the inquiry is at the time of enforcement. So, at the time of dissolution, would that waiver render a party reliant on public assistance? If the answer is yes, then generally the court would determine that that provision cannot be included or cannot be enforced. Other provisions that a court would generally in Connecticut not allow to be included in the agreements are provisions that address family support. So in Connecticut, the spouses are presumed to both be responsible for generally supporting the family, meaning providing a dwelling, a roof over the family's head, ensuring that the family has access to any kind of medical needs, hospital, doctor's care, etc. So a provision that would dictate that only one of the parties is responsible for providing for these needs would generally be considered unenforceable in Connecticut. Certainly, any provisions that contemplate one or both of the parties engaging in any kind of illegal conduct would also be considered unenforceable. The parties are prohibited from including that. Any provisions that would be considered to violate public policy or otherwise be immoral are also generally not prohibited from being included in the agreement. So, for example, um, any provision that the parties need to engage or requires the parties to engage in any kind of sexual relations would generally not be included in the agreement. It would be considered unenforceable if it is. Um, Certainly, provisions that speak to more domestic obligations or personal obligations as opposed to financial obligations of the parties are also more likely to be considered unenforceable if they're included, or generally should just be prohibited from being included in the agreement. And an example of this would be a provision that dictates that one of the spouses needs to maintain a certain weight. The courts generally would not enforce that. And certainly, any provisions that are so vague that the court can't determine what they are intended to do can't be enforced. A court can't enforce a provision if it can't understand the provision. So it's important to consult with an attorney to understand um, what can be included in your agreement and what can't be included in your agreement. You want to ensure that whatever terms you're including won't later invalidate your agreement. Certainly, if there are provisions such as addressing child support, including anything that would speak to a violation of public policy or a violation of law, these provisions can render your agreement unenforceable in whole or part at the time you go to seek enforcement of it. So it's important to consult with an attorney to really understand what you need to do to ensure that your agreement is compliant with Connecticut law.
Great. Thank you so much.